Hello and good day. My name is Sonia Kulkila and today I will be talking about easements and covenants which need reform. Is there a need for reform? The answer to that question is yes. There is a much need for reform in this area of law. This is because this area of law has become very important not only within our English legal system but within our own society. This being said, the current law which surrounds easements in England is very complex and holds many uncertainties, which leads to much confusion. Hence, the constant need and mention of reform. This area of law is very long established within our English law courts, is causing difficulty and unnecessary costs by its pure complexity. The Law Commission's report has highlighted many areas of law which need to be reformed. The topics which I have chosen to talk about are third-party interests in land, formations of easement within the same ownership, car parking easements, assumption of abandoned easements, and reform to the law of prescription. Covenants are put in place to repair a boundary or structure of a road. However, presently this does not bind successors. It would be beneficial to create a positive obligation which binds successively. There are many legal formations which could be used to underpin this problem. However, they all suffer from drawbacks which makes it unfunctional to operate. The Law Commission put forward many recommendations which have the power of binding successors compared to making an entirely new interest. Thus, the Law Commission proposes that land obligations can be both positive and negative. If this was adapted, the reform was to go ahead. It is good to note that it would also not have an effect on restrictive covenants. This is because it is impossible to create an entirely new restrictive covenant after the day of reform, which could leave existing covenants not affected. There is a criteria the Law Commission has created. This is because positive obligations, which are not the same as restrictive covenants, can be of great expense. It is key to note that the land will not be burdened with the mass of range obligations. At the moment, for an easement to be valid, the benefited and burdened land must not be owned or occupied by the same person. This being said, you can see the number of practical problems and difficulties which arise from this. The Law Commission brought forward an idea which states that if both areas of land are in fact registered, it should be possible for a landowner to create an easement over his or her land. Why is this useful? When looking at large developments of estate, taking into account residential content, this could be created and applied to each area of land before any sales have been made. Furthermore, if this was implemented, it would also facilitate mortgaging as part of a property. This is because currently some mortgages are reserved to agree the charge of part. This is because it is not easy to guarantee that if the borrower defaults, the mortgage takes possession and the charge which remains on the property can be sold with all the mandatory rights over land which is kept by the borrower. The Law Commission report has suggested a clarification on the test of certain rights which are capable of being an easement, thus passing to successors in titles of both benefited and burdened land. This being said, case law has left much uncertainty to whether particular easements which have the burdened owner without any understandable use of their land is valid. And one of the key areas which arises to this is car parks, the areas which you park your car, such as cases of Moncrief v Jameson. An easement was granted over Soviet land to access another dominated land, which was relatively difficult to access. The easement permitted vehicles to use the right-of-way to unload and unload goods and persons. The question within this case is, given the difficulty in accessing the dominated land, did the easement permit parking vehicles on the right-of-way too? The decision was held that yes, there were rights of easements are necessary for the reasonable enjoyment of land and may be in the complication when an easement was granted in 1973. They may be held to exist even where an area of land is fully occupied as a result of an easement. Ancillary rights negate the claim to exclusive possession, and the servient owner may still erect signposts to access his land and dig below it. This case was criticised but did not overrule Batchelor and Marlowe in 2011. The next case I will be talking about is Verdi v Channer. An easement allowed for parking half a car on an area of servient land of an equivalent size to half a car. The issue faced within this case was, did this amount to a claim for exclusive possession or denial of reasonable enjoyment of the servient land? The decision was held as no. This is because although the land would be filled when a car was partially parked on it, the servient landowner could still alter the surface of the land and its boundaries, amongst other things, rendering ownership. Batchelor v Marlowe 2001 was distinguished on its case facts within this case. The Law Commission has suggested that an easement should be valid but notwithstanding. This will prevent the burdened owner from making use of this land, thus would provide the validity and potential masses of car parking easements which are used in residential and commercial transactions. Having an easement over a site can cause many complications. If land has been chosen to be redeveloped, this in particular if the easements are old and do not appear to be exercised for many years. However, this being said, it is very much possible for an easement to be ended, through abandonment. Although the courts in present day are reluctant to assume a right would have been abandoned, the Law Commission has raised a good point as to where an easement has not been used continuously for an amount of time, this being 20 years or more. There should be a presumption that it has been left abandoned. However, the presumption can be rebutted if reenacted. If this was to be implemented, the positive outcome would be from this proposal could assist developers whose sites are being subjected to obsolete easements. The law of prescription is very outdated and allows certain rights to acquire through long use. The method which is used is the three existing method of prescription. However, the Law Commission has proposed that this method is replaced with a single statutory scheme in relation to easements. The Law Commission has similarly stated that existing methods of how an easement should be applied should be replaced by a statutory test. When looking at this, it would simplify the law while allowing the usefulness of the current law to remain. Conclusion. All of the areas which I've spoken about are surrounded by great complexity. The Law Commission report proposed over 68 changes, for which I have decided to highlight surrounding my chosen topic area. The reforms which I have mentioned, I wholeheartedly believe have a positive outlook on the area of land law in relation to easements and covenants. Also, I would like to state that this area of land law is very time consuming and requires a lot of expense. This being said, if the Law Commission report implements these changes, it will save time and money within our society and allow developers to develop on-site easier compared to if the reform had not been taken place. Thank you for your time and listening to this presentation. I hope you enjoyed it. Thank you.